Good evening, tenants and citizens of the District of Columbia. Thank you for joining the Office of the Tenant Advocate for this virtual mini summit on Tuesday, September the 17th, entitled Apartment Building Security Problems and Solutions. This evening, we hope to bring to you a panel of experts that will talk about the 2024 Safety Act proposed by the Office of the Attorney General, and hopefully it will illuminate solutions to the security problems that you face in your apartments today. I hope that you enjoy the session. I'll now turn the program over to Joel Cohen, our Director of Policy and Legislation, who's been with the Office of the Tenant Advocate for the past 16 years. Take it away, Joel.
Thanks everybody for being here. And let's see, as Johanna said, I'm Joel Cohen. I'm Legislative Director at the Office of Tenant Advocate. Welcome to this panel discussion entitled Apartment Building Security Problems and Potential Solutions. First, let me speak about the context for this forum. Over the past several years, complaints from tenants to the OTA about apartment building security have spiked dramatically. At the same time, media stories about security lapses in apartment buildings have surged. Buildings in all areas of the district are affected, including older buildings that until recently were considered luxury apartments and new buildings that continue to be advertised as luxury apartments. They involve public as well as private rental accommodations. The security concerns that tenants raise are sprawling. They include unsecured entryways, the presence of intruders, some of whom engage in unlawful activities once inside the building. They include gunfire onto the property from outside the perimeter, and tenant-on-tenant violence or threats of violence from within the building. It is in this context that in July of this year, the district's Attorney General, Brian Schwab, introduced, actually Chairperson Mendelson on his behalf, introduced the Secure Apartments for Everyone, or SAFE, Regulation Amendment Act of 2024. This is Bill 25-918. Just today, Bill 25-918 was jointly referred to two council committees, the Committee on Judicial and Public Safety, chaired by Councilmember Brooke Pinto, and the Committee of the Whole, chaired by Councilmember Mendelson. To discuss these issues, we are fortunate to have with us representatives from the Attorney General's office and from the advocacy community, as well as from the OTA. This is a 90-minute session, 60 minutes per panel of presentations and discussion, and then 30 minutes for Q&A. We are dividing for 60 minutes roughly into three parts. First, we'll hear about the tenant community's concerns and issues regarding apartment building security. For this topic, we have two presenters. Cristobal Buch is Director of the OTA's Education and Outreach Branch. And Danielle Del Pielago is the Housing Director at Empower DC. Cristobal and Daniel will each have about 8 to 10 minutes to describe tenant complaints that have come to their attention and their organization's attention. I'll note that General Counsel Dennis Taylor is also on hand. He's General Counsel for OTA to handle do some comments or address a question as needed. Then we'll turn to potential solutions. Damon King is a policy advisor at the Office of the Attorney General. Damon will have about 15 minutes to explain what is in the Attorney General's SAFE Act proposal and its policy objectives. Also, Beth Mellon, Assistant Deputy Attorney General for OAG, is standing by to address issues and questions as needed, backing up Damon. Then Joey Trimboli, who is the OTA's Legislative Counsel, will have 8 to 10 minutes to discuss currently applicable laws generally and regulations, gaps in the law, and pending legislation that may be relevant, as well as the SAFE Act, of course, or could be made more relevant. As time permits, within the first 60 minutes, we'll ask the panel to raise any additional points they'd like after the presentations are over, or just to engage in some follow-up discussion with each other. The last 30 minutes, we are saving for Q&A. We ask that you please submit questions in the chat anytime during the first 60 minutes of presentations. And please let us know which panelists or panelists would like to respond to your question. Cristobal will pose questions in the chat to the panelists, and I, as moderator, will have some questions as well. So with that, we are going to turn to Cristobal to open this up.
Thank you, Joel. So I am the Education and Community Outreach Director for OTA. And as part of our job, the Education and Outreach team, we hold classes, workshops, and listening sessions throughout the District of Columbia. And in doing so, we receive repeated concerns from the tenant community regarding security and safety in residential housing accommodations. Importantly, these tenant security concerns are not limited to one particular ward or one particular area of the city, but throughout the district. So among the top concerns that we've heard from the tenant community are, for example, unauthorized individuals inside buildings, engaging in the use or sale of narcotic drugs, and leaving drugs or paraphernalia in common areas of apartment buildings, unauthorized individuals gaining entrance to buildings and sleeping in the laundry facilities, stairways, corridors, and even the roofs of certain buildings, vandalism in laundry facilities, community rooms, and shared spaces, theft of clothes and laundry facilities, as well as unsecured doors, main entrances, and doors that lead to the outside of the building, as well as garage doors, which lead to the theft of personal belongings and tenants' vehicles, and also the theft of vehicles. We've also heard that when vehicles are stolen from building parking lots, management often refers to a parking addendum that releases management liability for the theft of personal property and or the vehicles. Joel mentioned certain tenant activities as well, such as tenants allowing unauthorized individuals in buildings who then engage in other unlawful or criminal activities as well. We also have certain security precautions that could be taken that aren't, such as no sign-in and sign-out registries at buildings, which adds to the lack of safety and security in buildings. At some buildings, where, for example, where there was previously security services or a concierge service, those services have been either entirely cut or have been, or the hours have been reduced, which increases the sense of insecurity of tenants in those housing accommodations. Along with that, faulty electronic doors, fob keys that are easily copied so that unauthorized individuals are allowed entry into buildings. And then one important other issue that we see often is the lack of emergency personnel access to buildings. So that when the Metropolitan Police Department or the DC Fire Department Emergency Medical Services need to go to a building, they are not able to enter the buildings, right? And then lastly, unprofessional security personnel and or management personnel, which adds to a sense of lack of safety and security in those buildings. So those are some of the examples that we hear from the tenant community. But also another issue that we hear of often is that when criminal activity does occur, management doesn't communicate to the tenants what has occurred. So tenants often hear about criminal activities through the grapevine, right? And that's kind of like playing the game telephone, right? And each time somebody hears the conversation or each time it's shared, it changes a little bit, right? So that is that adds to the sense of insecurity or lack of security, and it's unnecessary, right? These incidents, right, include both property crimes, theft of personal property, damage of personal property, but also violent crimes, right? Such as active shooting incidents within housing accommodations, stabbings, and other violent crimes. So tenants have a lot of difficulty getting that information from management. An added difficulty would be when tenants need to get security camera footage from management in order to file a police report, and then management simply refuses or says that the tenants need to get a subpoena or some sort of other court order in order to get those. So lack of access to information is key, and then a lack of cooperation from management when security incidents do occur. So lastly, I'm going to speak about 3 particular security incidents that happened at buildings that the OTA's Education Community Outreach team has worked with frequently. So in one such case, at a particular building that we've been working with that tenant association for a long time now, they informed us that an unauthorized individual got into the building through the main entrance of the building. This individual then ripped off a large screen TV from the lobby of the building and then ran out with it. Now, one time enough. At this building, this happened twice. right? We've also had when the education community outreach team goes out to give classes, workshops, or trainings, we've also had tenants show us bullet holes in lobbies of buildings. Now, lastly, that one building that we work with quite a bit, a particular tenant had a medical emergency, serious medical emergency, and the responding EMS personnel was not able to gain entry into the building because there was no overnight security and the keypad didn't allow access to emergency personnel. So eventually, another tenant saw the red emergency lights from the fire truck and went downstairs and opened the building so that EMS could go in and give life-saving medical emergency treatment to the tenant. All of these are among the concerns that tenants voice to the education and outreach team on a daily basis when we go out to work amongst the tenant community. Having said that, Joel, I'll pass it back to you.
Sorry about that. I was on mute. Daniel Del Piolago, are you ready to go?
Yes, thank you. Thank you, Joel.
You're on. Thanks.
Thank you. And thank you, Cristobal. Let me thank OTA for this important conversation and our friends over at OAG as well, because this is an important conversation. I'll start by saying that often, or let me say a specific event. About a year ago, we held a focus group with primarily public housing residents around what the issues that were affecting them. And we expected to hear a lot about conditions and the issues that exist for many renters. But what floated to the top mostly was the security issues, security and safety issues. So this is a timely conversation that I think needs to be had. I myself, in preparation for this meeting, I shared that one time at Berry Farm, when I was doing some outreach there prior to it being demolished, I knocked on a door of a vacant unit unknowingly. And when I opened the door, it had the screen doors to get to the main door. When I opened the screen door, what did I see? Some really heavy artillery, guns. And that was definitely not from the people that were living there. So I think it is really important to have these conversations, but how nuanced it is as well, right? Because we don't want over policing, over criminalization that could lead to tenants being evicted or being pulled into the criminal justice system, especially on properties like public housing, where some of the rules are a little different around the proximity to crime and criminal activity, right? If somebody in your family gets caught with something, the whole family could potentially be put out. So I think that's important to note in this conversation, and these solutions should really be informed by tenants as well as the whole community as we're having the conversation here today. I think once again, I do want to reiterate the importance of making sure that vacant units are secured. I agree with a lot of things that Cristobal said, but I think, one of the things that comes up for us is, these young boys, they're in the vacant units doing, things that we don't want them to be doing. I think that's really important to consider in this conversation is the vacancy rate on many properties, especially in public housing that has here in the district that has a very high vacancy rate, which allows people who oftentimes don't even live on the property to use them for activities that are, illegal or criminal. So I think that's important to note. I think another big piece that we often hear is this outside influence, right? People from outside of the community coming in, identifying, properties that it's easy to have access to units. So I think we have to be able to monitor that as well and have that be part of the discussion. The other big piece that I think, and I agree, oftentimes the unsecured entrance doorways to buildings is a big issue. I will say that oftentimes the problems that happen is, you know, oftentimes in larger properties that have higher count bedrooms, right? 4 bedrooms, which are meant for families, is that there could be a significant amount of people living in one unit, right? Because it is a large family. Public housing, you know, has, for example, with the community we work with a lot, there's 6-unit apartments in some properties. So what happens often is people are there's not enough key fobs. There's not enough keys to the entrance ways, and that creates a lot of issues, I think, for folks. So I think all of these kind of nuanced things are very important to consider when we're having these conversations, because ultimately, folks want a safe and secure place to live, right? And if they have to worry about you know, outside influences or just criminal activity in general, it doesn't allow us to focus in on some of the very real issues that they live within their homes. So once again, I think this is an important conversation for us to have, and to remember that the solutions, I'll say this, and I don't know if folks will agree, but there is a kind of a push right now for many tenants where they are feeling pressured, right? Around the budget for funding, for, you know, subsidies and all the likes. So there is a major push where tenants in the district are feeling like they're getting picked on. So solutions shouldn't, you know, make that any worse. The solutions really should, once again, be informed by the community, in partnership with the community, because I think we'll find that the majority of people want to find ways to make sure that everyone is safe, that no one gets hurt, and that people are able to enjoy their properties and their buildings. And I think, you know, and oftentimes it's not just the building. People want to go to the playground and be able to take their child to the playground and enjoy the playground. So I think it's all of those kind of things that we have to consider that are important. And with that, I'll leave it at that. I know we're running a little bit behind, but glad to answer any questions or anything else. Thank you so much.
Thanks, Daniel. Great. And Damon and OAG.
Wonderful. Well, I want to thank you, Joel, and the team at OAG for inviting us to participate in this program. We're really excited to talk a little bit about the SAFE Act. Just to remind everybody, my name is Damon King, and I'm a policy advisor here at OAG. I am also joined by my colleague, Beth Mellon, who is an Assistant Deputy Attorney General for OAG's Public Advocacy Division. We're going to talk a little bit about the SAFE Act today, the Secure Apartments for Everyone Amendment Act, or the SAFE Act for short. The legislation is a response to concerns that we've been hearing from tenants across the district regarding security problems in their buildings. Problems that they do not believe that their landlords have sufficiently addressed, and that ultimately are leaving people feeling less safe in their homes and communities. The act would give the district new tools to address these security problems and strengthen a key existing tool that OAG already uses to address properties that face the most serious security concerns. I'm going to go ahead and pull up a PowerPoint presentation. I really want the focus of tonight's session to be on answering questions and having discussion about the legislation. But I do want to start out by just talking a little bit about what the legislation does. So I am going to open up slideshow and begin. So can everybody see the slideshow or the beginnings of the PowerPoint? So, all right, then we will get started. So again, this is the SAFE Act, Bill 25-918. And we're going to go over these points over the course of the PowerPoint. We're going to start by talking a little bit about current practice, what OAG currently does. when it receives complaints about security concerns at apartment properties. In the course of doing that, we'll highlight both the strengths and the weaknesses of the main existing tool that we have, which is the Drug, Firearm, and Prostitution-Related Nuisance Act. Once we've gone over that, we will then move on to the SAFE Act, because the SAFE Act is meant to both strengthen that tool and to add additional tools that hopefully will allow us to address security issues at properties before they get out of hand. So in order to talk about current practice, I'm actually going to turn it over to my colleague, Beth. And she's going to talk about how OAG currently uses the Nuisance Act.
Good evening, everyone. Echo the thanks that Damon shared. So OAG's main tool that we have for addressing security issues at residential rental properties, which we're talking about tonight, is this law called the Drug, Firearm, or Prostitution-Related Nuisance Abatement Act. That's a mouthful, so we're going to call it the Nuisance Act. When we're talking about it, we have a citation here to where you can find it if you want to look it up. And this is the main tool that we have when folks are coming to us, tenants, neighbors, community members, leaders, about safety and security concerns. So when is a property considered a nuisance under this law? And that's what's required to allow the Attorney General to take action under this law. It's, as the name sounds, we have to have a property where we are seeing prostitution. So the property is being used to facilitate prostitution. It's being used to unlawfully store or keep firearms. It's being used for the sale or manufacture of controlled substances. Part of what's important to understand here is this law does not cover all safety or security problems at properties, and it does not even cover all types of crimes. So there's a specific definition in the law, and we will look at properties to see if this is a tool our office can use. That property has to meet the definition in the law and fall into one of those three categories. And then in terms of what we do, to explain a little bit of our process. So like OTA, and as Cristobal was talking about, as Daniel was talking about, being out in the community, our office gets referrals from community members, elected officials. We hear from council members. We hear from ANCs. Who are concerned about particular properties. And we do encourage folks, if you're concerned, if there is a property and you feel like it might meet this law, and you've reported illegal activity to the Metropolitan Police Department, because if you're seeing criminal activity, we certainly encourage that as well. You can contact us, our Housing and Environmental Justice section, which falls under the Public Advocacy Division that I help lead and manage. You can contact us. There's an email address here, housingjustice@dc.gov. We also have a phone number. That phone number is for our mediation hotline. But if you get there, then the referral will be passed on. So what do we do when we get a referral? We investigate, and that includes a lot of different things. One of the first things we'll often do is pull the MPD incident reports to just see what has been reported. Are we seeing criminal activity that is confirmed? We also talk to community members. If an ANC member or a member of the council or staff, they may be in touch with tenants, we will talk to those tenants. There may be neighbors who are concerned. We will talk to those neighbors. We also often will talk to MPD about a property, because some of these properties already are known to MPD, and they have concerns, and they may be making observations about the property or the neighborhood, or frankly other properties nearby that they have concerns about. And so what's important about this law and what we do if we think a property meets the definition is we can go to the owner of that property and ask for certain things to be changed to make the property safer. For the residents who live there, for neighbors, for everyone who is concerned and may be impacted by the property. And so generally what we do is we reach out to that owner. We often send them a letter, because we need to give them notice and make sure they understand that we're concerned and why we're concerned and what we're seeing or what's being reported to us. And we will then start a conversation with them where we are asking for particular steps to be taken in terms of improving security. Doors have been mentioned as an issue. Sometimes there are properties where windows are not working. There may be some things that are housing code violations, but sometimes there are other things. Cameras were mentioned, other ways that properties try to maintain security. And sometimes it might be something that you wouldn't immediately think of. There might be a property where adding a fence, removing a fence, having some lighting, things that may or may not be required by the housing code. And Damon will talk a little bit about or thinking about how to then address kind of the current situation, are things that, in talking to MPD and talking to residents who live at the property, folks have ideas about if there was more light in this area, or if there was a fence here, or if there was a camera at this location, maybe that would prevent and deter some activity that's happening on the property, or would prevent folks from getting into the property who shouldn't be there. So some of the advantages of the law and some disadvantages. So, we can pressure landlords to make security improvements. We can provide them information. We can have a conversation about what would help. And this is, we think, an important tool for properties with very serious security and crime problems, properties that meet that definition under the law. First of all, there are crimes that just aren't covered by the law. This law is intended to really focus on serious crimes, serious security issues. It's not going to cover every property where there are issues. It also takes time. Anytime you go to court, it's just going to take time. And it's not preventative. And so we are really bringing these lawsuits to react to a situation. And in thinking about these problems and hearing from residents, and thinking about how to possibly respond with some legislation, we really would love to be more preventative, prevent problems from before they start, or if we're starting to get some signals that there are problems at a particular property, what can we do before something serious happens? Because we need serious crime to be going on to use this law, and that's not where any of us want to be in terms of a property where families and individuals are living.
So now we will transition into talking about the SAFE Act and what the SAFE Act does. So, as my colleague said, SAFE Act is intended to give the district new tools to try and address security issues earlier and more quickly. Our goal here really is to make sure that the district has the tools to get to properties before situations get out of hand in terms of security. Now, the Act does this in a few different ways. First of all, the Act proposes amendments to the district's property maintenance code that would require landlords to make what we view as common sense preventative steps, common sense preventative steps to secure their buildings. And these requirements would apply even before a building starts experiencing major security problems. Second, when a property experiences early signs of security problems, the Act would require the government to respond. And then finally, the Act would strengthen OAG's power to use the Nuisance Act at properties experiencing gun crimes. Our hope is that if we take prevention, early response, and improvements to the Nuisance Act and combine them into one unified approach, we'll end up with a menu of policy options that will allow the district to address the needs of properties at varying levels of security need. And again, intervene before properties become out of hand. So we'll go over the specific provisions of the Act. So first of all, in terms of prevention, the Act updates the property maintenance code in two key ways with respect to buildings that have 5 or more units. First, it requires that all exterior doors to a property be self-closing and self-locking. The hope is that by adding a little bit more specificity to existing requirements around doors and locks, we can help address the problem of unauthorized access to buildings. Secondly, again, at buildings of 5 units or more, the Act would require a property owner to maintain exterior lighting at exterior doors to the property. The lighting would have to meet minimum brightness standards and also stay on from sundown to sunrise the next day. We believe that by creating these new minimum requirements around exterior lighting, it'll help deter illegal activity around the perimeter of properties and also just make people feel safer as they enter and exit buildings. So the next step in the act beyond prevention is early response. And what the act would do is it would create a requirement that when a property experiences early signs of security problems, DOB would have to go out to the property, assess the property for potential security vulnerabilities, and issue a report to the property owner with recommendations for security improvements. Some of the things that Beth listed when she talked about things that a property owner might do in response to a nuisance letter. Our hope is that if DOB goes out before the property ever reaches nuisance status, then the property owner could end up implementing some of those improvements earlier. And again, it would prevent the property's security situation from escalating. As it's drafted currently, the legislation will require a DOB security assessment when a property experiences one of three potential triggering events. So one is if there are 2 seizures of controlled substances at a property in a 3-month period. The second is if there are 2 seizures of firearms in a 6-month period. And then the third is if there are arrests for crimes of violence, two arrests for crimes of violence or dangerous crimes at a property in a 6-month period. Now, security recommendations made by DOB under this process would be non-binding, so the landlord wouldn't be required to follow them. However, any recommendations that DOB makes would be shared with OAG, the ward council member where the building is located, the local ANC where the building is located, OTA, and also the president of the building's tenant association if the landlord is aware of an existing tenant association. The recommendations would also be accessible by tenants at the building. So informing these groups of folks about the recommendations, we believe will put pressure on the landlord to address security vulnerabilities, even if the recommendations aren't required. And then finally, in addition to prevention and early response, we do want to make some changes to the Nuisance Act itself. The most notable change is that we want to broaden the definition of a nuisance when it comes to firearms. So currently, a property can be considered a nuisance if firearms are stored or kept at the property. When guns are seized at a property, this can be evidence of them being stored or kept there. And so that's why, as Beth highlighted, we look at police incident reports, we look to see if there have been seizures of guns. However, we don't have as much flexibility as we think we need under the Nuisance Act when there's been a gun crime at a property, but there hasn't been a corresponding gun seizure. So we try to address that. The SAFE Act would redefine a nuisance under the Nuisance Act to include properties where there has been a crime of violence or a dangerous crime involving a firearm, and that's whether or not a gun was stored or kept at the property. Now, in addition to that change, we've made a few changes, or we propose a few changes that would kick in if we do engage in litigation over a property. So first of all, if we do file a lawsuit regarding a property, we want to allow the court to order a security assessment as part of that ongoing suit. The hope is that if the court orders that security assessment, it would ultimately lead to better orders from the court when it came to sort of required security improvements as part of that case. We also create a standard for the court to use when considering ordering private security. We know from experience that many residents feel that private security is part of the security solution when it comes to properties. But we also know that for landlords, private security can be expensive. So we wanted to provide some guidance to the court as to how to weigh requests for private security against costs to the landlord. And then finally, we provide more clarity regarding daily damages that a property owner must pay when they've left a nuisance unabated. Right now, the Nuisance Act provides for damages, but we've actually provided some more details in terms of daily amounts that will help with damage calculations. So before we move on to the next part of the presentation and hopefully being able to answer some questions, I want to put my contact information up so everybody can see it. If you have questions or would like to provide feedback on the SAFE Act outside of this session, I want to encourage you to reach out to me. We are still very much taking input on this. Also, just to provide you an update in terms of where things stand procedurally. As Joel did mention today, the SAFE Act was officially referred to the Committee on the Judiciary and Public Safety and to the Committee of the Whole. Our understanding is that those two committees will hold a joint hearing on the legislation this fall. We are expecting that hearing sometime in November. And that is an opportunity for everybody to weigh in on the legislation. If you believe that the legislation will help your situation or help improve security at buildings across the district, we absolutely want to hear from you, and we'd like for you to participate in the hearing. If you believe that the legislation needs some improvements, if there are things that you are seeing in your day-to-day that the legislation should try to capture, this is also an opportunity, and we want to hear from you as well. And so you can come out and testify on the bill and give your views. We're hopeful that coming out of that process, we'll be able to make some improvements and refinements to the legislation and ultimately end up with a bill that's going to position the district to address these security concerns at properties. And again, address them earlier, more quickly, and more effectively. So thank you, everybody, for the opportunity to talk, and we're looking forward to answering questions and to talking about the bill in more detail.
Great. Thank you, Damon and Beth. Joey, you are on.
All right, thanks, Joel. So first I'm going to begin by sharing my screen as I have a PowerPoint here. So let's see if this works. Okay, can everybody see the PowerPoint? Seeing nods. All right. So good evening, everyone. My name is Joey Trimboli. I'm a legislative counsel with the Office of the Tenant Advocate. Tonight, I'll be going over some current regulations in the district's housing code and property maintenance code that are relevant to keeping tenants secure from intruders and other threats at the rental housing properties in which they live. I will also briefly discuss two pieces of legislation currently before the DC Council that may potentially be relevant to rental housing safety and security, aside from the SAFE Act. So to start with, the first category of regulations I'll discuss include those regarding windows and doors. I know this looks like a lot of text, but the key pieces are those that I've put in bold and italics, so I'm going to mainly focus on highlighting those. First, windows must be equipped with a sash locking device. This is the standard window lock I imagine most of us have seen that consists of two interlocking pieces so that when the window is closed, you can push a lever to lock those two pieces together. Window panes must not have open cracks or holes, which you could imagine might offer an opportunity for an intruder to perhaps pry open the window or manipulate the sash lock from the outside. Windows must be capable of being easily opened and held in place. For those on the ground floor, this might be an important means of exiting in an emergency scenario. Door latches must be in good condition to keep your door properly closed. Doors to the exterior must have locks that easily allow you to exit without a key, but also prevent entry from the outside without a key as well. I'll note that this is an example of how the SAFE Act would improve the existing regulations. You'll note that these regs shown here do not require doors to the exterior to automatically lock when they close, so that someone doesn't need to manually lock that door. The SAFE Act would require automatically locking doors so tenants can be assured that the exterior doors to the property will not allow easy entry by unauthorized individuals. And the second category I'll go over is lighting. So in common spaces and stairways, means of egress or exit for properties with multiple units must be illuminated at all times. In addition, illumination in hallways, stairways, and common spaces must be provided at any time that natural daylight does not provide an illumination level of at least 6 foot candles including from sunset to sunrise. And a foot candle is a technical measurement of the brightness of light. This is important for building security because it discourages, let's just say, mischievous behavior or perhaps undetected intrusion in common areas and stairwells, which might not see as frequent foot traffic as hallways and elevators and what have you. Lighting is another area of regulation that the SAFE Act would improve upon, where the property contains 5 or more units. As Damon just discussed, that legislation would require lighting that illuminates the area outside of the building at the front entrance, anywhere from 100 to 300 watts, depending on the size of the area that needs to be covered. And that bill would also require similar lighting at other exterior entrances to the property, as a Department of Buildings official may prescribe. And here I'll just go over a couple of miscellaneous regulations on other kinds of entryways besides doors and windows. So specifically basement hatchways, which are probably unlikely to be a common feature at most rental properties, must be equipped with a device such as a lock to prevent unauthorized entry. And second, gates must have latches that securely close the gate. Note that it does not say gates must lock, but of course a closed gate is at the very least hopefully going to somewhat discourage unauthorized entry in the sense that it doesn't say to someone, welcome, come on in. And from there, I will move on to a couple of bills currently before the DC Council, other than the SAFE Act, that may be relevant to rental housing security. These bills don't go directly to security measures per se, but they do go to the responsibilities in general of those who are licensed to own and manage rental housing as a business. So first, the Do Right by DC Tenants Amendment Act. This bill would deny housing business license or license renewals to property owners who are cited for more than 5 Class 1 or 2 code infractions within a year. Class 1 and 2 infractions are generally the more severe code infractions that tend to put the tenant's health or safety at risk. For example, a Class 1 infraction could include flagrant, fraudulent, or willful violations that endanger the safety of tenants or the surrounding community. Such an infraction could potentially include a landlord's failure to maintain some of the legally mandated features that I mentioned earlier, and perhaps also the exterior lighting and self-locking doors the SAFE Act would require if it becomes law. And finally, the second bill I'll highlight is the Licensing for Accountability of Management of Properties, or LAMP Amendment Act of 2023. So this bill, as introduced, would simply require property management companies to acquire a license in order to operate in the district. Note that individual property managers are already required to be licensed. The OTA has recommended to the council that this bill be amended to put teeth into the licensing requirements and to make property managers accountable for failures to meet their responsibilities, whether the property manager is a firm or an individual. Currently, most of the bases upon which the Real Estate Commission might take away a property manager's license have to do with the licensee's responsibilities to the owner of the property. In other words, the one who's hired the property manager to work on their behalf. So that includes things like responsibly managing rent money that the manager is collecting from tenants on behalf of the owner, and things like that, fiduciary responsibilities. So we at the OTA would like to see those bases for license revocation expanded to include things like consistent, severe, or bad faith failures to maintain compliance with the housing code or property maintenance code. And that could include code requirements that keep the property safe from intruders and other security threats. I'll also note that we've identified multiple national professional associations of property managers that include responsibilities towards tenants as opposed to just owners, as ethical responsibilities for property managers. So we think those obligations should be written into district law as well. And those should likely pertain to security measures that we're discussing tonight. So that concludes my presentation. And with that, I will kick it back over to Joel. Thank you.
So thanks, great presentations for everybody, so thanks very much. We have a little bit of time for some crosstalk and panelists sort of follow-up discussion with each other. We're back on track, so thanks everybody for being speedy, going through your presentations. I'd like to start by asking the panel, probably primarily Damon and Joey, if we can sort of highlight for everybody the difference between the existing security regulations and what's in the bill. That was explained very well, but there's a lot of information. So just to underscore, Damon, do you want to start out talking about just how the like the entryway requirements would change, or Joey can do that? Either one of you would be fine.
Yes, I can start, and also Beth, you should feel free to join in as well. I think our attempts to update the code are really around sort of providing additional detail on both those elements, doors and lighting. In terms of doors, self-closing and self-locking mechanisms, I think, are sort of the key thing. The hope is that those requirements will prevent sort of situations in which people are easily able to leave doors open, exterior doors open. And when they close, also, it'll prevent folks from sort of just following behind sort of very quickly and reopening the doors. In terms of lighting, we want to provide some additional detail there as well, and have something that is dedicated to exterior lighting rather than sort of requirements that are folded into stairways and hallways. And so the hope is there, if we have something specifically dedicated to exterior lighting, and also some new language around brightness and duration, that will help as well. Beth, I don't know if you want to add to those points.
Nope, that's great. I mean, the security assessment by DOB is obviously a brand new practice that if we bring a case right now to court, we can ask for, or we can do on our own, but it would be great if those kinds of ideas earlier in the process are part of the process as well. And that ties into DOB. It's not the code requirements, Joel, but to the extent you're asking about, kind of what else, for example, would DOB be doing, that is important.
Right. Okay, great. Thanks. Joey, did you want to add anything?
Yeah, I would just briefly add that in reviewing the regulations, a theme to me that I noticed was that, especially regarding lighting and doors, locking of doors, is that the theme seems to be easy and safe means of egress for tenants from the inside, rather than protecting from unauthorized entry from the outside. So I think that's where the SAFE Act comes in to improve that in that respect.
Yeah, good point. Okay, well, I think with that, does anybody have a follow-up point to anybody else's presentation, or a question you want to ask? Or we could do all that in the Q&A, which is about to start. Going, gone. So we're just going to start the Q&A, and Cristobal is going to start out with 3 questions posed by tenants during education and outreach events at on video. So Cristobal, I'll turn it over to you for the videos questions.
Thank you, Joel. So, yep, if we could roll the tenant questions now, please.
Good afternoon. I'm Mrs. Reed. I live in a senior building, and I'm not safe here in the building that I moved in 20 years ago, which provided 24-hour security. And now we don't have any security to mention of. And there's no sign in, sign out.
Let's go ahead and ask one question
Our
from the
roof,
chat,
I
and then we can
understand,
go
has
on
been
to that.
broken into.
So one of the first questions that we got this evening was, what about security cameras that are inoperable on a property? Does this legislative proposal address this, or is that something that could be added to it? Yeah, what about security cameras that are inoperable on a property is a tenant question from the chat. We can start with that one.
I think that's a great question. And I think, one of the things that we would hope with this legislation is that through that security assessment mechanism, it would allow somebody from DOB to come out and to look at all security vulnerabilities, including things that are inoperable. And so if that person comes out to the property and they look and they see, hey, there's a security camera that isn't working, or maybe that we need security cameras in other locations, or a larger number of security cameras, there would be room to make that recommendation for the landlord with that guidance to then make improvements. So we're really sort of hopeful that that security assessment piece will give both DOB and property owners sort of the chance to address situations in which there are sort of very individualized needs of a building and very individualized problems, like security equipment that's not working properly.
And I'm going to ask a follow-up right there, because that's a great segue into something, Damon, you and I were discussing in preparation for the event. And that is that a camera, having a camera on site is not required. And therefore, if this goes to the distinction between an assessment report that is triggers the DOB security assessments, which results in, as I understand it, recommendations that could go beyond housing code compliance, but can't require the housing provider to, execute on those recommendations. Would it be, there are plenty of housing code regulations that do not require things, but if those things are on the property, they are required to be kept in good working order and maintained. That sounds like it could be an easy addition to the legislation to require cameras if present, minimum if present, that they be operable and maintained. Is that a sound proposition for possible OTA recommendation when we testify in support of, say, that?
So I think that's the type of recommendation that we absolutely would like to hear. I think, in putting together this legislation, one of the things that we were thinking about is sort of that on the one hand, the security assessment process provides a way for really individualized and property specific recommendations. And we want to give DOB a lot of latitude in making those recommendations. The challenge with that approach is that recommendations are going to vary significantly from property to property, right? A DOB staff person, a DOB inspector could show up to one property and make sort of very minimal recommendations, small recommendations that would nonetheless have a larger effect, or they might end up making sort of very significant recommendations that will be challenging to implement in some ways and could also be costly. And so because there's sort of a range of things that DOB could recommend under this legislation, we didn't think that it was appropriate. To make recommendations mandatory. And so that's why we took a step back from that and made them non-binding. That said, I think that's, that idea that, if a property has security equipment already installed, that it should be operational. I think that's an interesting idea, and we actually, I think, would appreciate hearing recommendations like that at the hearing on the bill. We view this bill as sort of a starting point, and so being able to gather feedback like that would be really important for making refinements down the road.
And to take that point one step further, as you were explaining during our conversation, the court ordered assessment report is different in that the court could order those non-housing code violation repairs or adjustments to be made by the housing provider. So what DOB cannot do above and beyond the housing code, with the property maintenance code, the court could certainly order by way of resolving the case.
Yes, that is true. If a property reaches the point that we bring a nuisance action, then under that action, the court can make an order.
Got it. Cristobal, I'll throw it back to you if you're ready with videos.
Yes, thank you, Joel. Okay, now we're gonna roll the tenant questions. So Thank you.
Yes, I have a problem with security here where I live in the senior building. One of the main issues for me is coming in through the roll doors, the garage. People stand there and wait, walk in cars, wait until you, drive through and they follow you in. Then we have the door going into the building proper. They will follow you in there and take the elevator with you upstairs. You don't know who they are and you're not going to stop them. It's twice the size. Once you get in the building, we still have an issue with the front door. People follow you in the front door. So here again, you don't know who they are. You don't feel safe. There's no light out front, and it's very scary to come in here at any time. And you still have strangers following you around here, which makes you feel very unsafe. We would like an on-site security system, so with screens, so they can tell when someone's coming into the building and handle it from there. Thank you very much, and I pray your proposal can help us and guide us with our security problems.
I live in a senior building. One of the problems that we have here is the lighting outside of the building. It's not safe. They don't come on at night. Security is a high priority for us. Someone could come in the door behind us that don't live here. We feel uncomfortable with that. So what can your proposal do to help the residents here?
Good afternoon. I'm Mrs. Reed. I live in a senior building, and I'm not safe here in the building that I moved in 20 years ago, which provided 24-hour security. And now we don't have any security to mention of. And there's no sign in, sign out. The security, our roof, we understand, has been broken into. People have been sleeping up there and in our community room, on the staircases, and in our laundry rooms. And I would like to know, what will this legislation do to help me and the residents here at this senior building that I'm residing in?
Those are 3 questions from the tenant community, and please, panelists, feel free to provide responses.
So I can open things up, and I would definitely want to hear from my fellow panelists as well. First of all, I'd like to thank Ms. Reed and the other residents for submitting those questions. I think they go to some of the common problems that we're trying to address through this legislation. You heard references to doors, and to non-residents following residents into doors that are open. You heard references to lighting around properties. And those are 2 things, of course, where we want to add some more detail via changes to the property maintenance code. But I think what you also are hearing from those residents' questions is that, security doesn't come down to one particular feature, one particular thing that if you change that, it just changes everything. I think what you're hearing, or what I'm certainly hearing, are calls for a really comprehensive approach to security, an approach that looks at several different elements that could be addressed by several different, or a combination of security improvements. And that's really what we are trying to get at through the security assessment portion of the bill. Our hope is that when there are, again, early signs of the property, that things may be headed downhill in terms of the security situation, various types of criminal activity, arrests, that somebody can come out, put eyes on the building, put eyes on the property, and identify, here are all the ways in which this building may potentially have some vulnerabilities. And here are a combination of changes that you as property owner can make to make the residents who live in your buildings feel safe. And so that's really what we're after, that comprehensive approach to security, and that comprehensive approach that can be implemented before we get to the point that a property is potentially a nuisance and we're talking about potential civil litigation, which, as my colleague mentioned, is is both is time intensive and doesn't necessarily lead to improvements quickly when residents are suffering.
If I could just add something real quick, and I'm very curious if, I don't mean to put you on the spot, Daniel, but you may have some thoughts, I recognize, but just an example of something that maybe is a little more creative, because I know a lot of folks, especially if they've had private security at a property, may want that back. Other residents may not feel comfortable with that. It's also very expensive for owners. We had one property where some shootings were happening from outside of the property onto the residential property. And in talking to tenants and folks who work on the property, they pointed out that there was a particular line on the property where there was a tree line and a chain link fence, and there were folks coming from outside, standing on the other side of that fence and shooting into the property. And then because the fence was a barrier, you know, they were kind of running away before anyone could come after them. That owner decided to put up blackout fencing that blocked the view. And that was a very simple, relatively inexpensive solution to just a practical issue. That's just an example of something that happened to work for that particular side of that particular property to really improve security and decrease some shooting that was happening onto that place where families, children, you know, were living every day and were fearful. And so I just want to offer that as an example that, you know, it's, as Damon was saying, lots of different ideas, lots of different solutions, and sometimes just sharing the information and starting a conversation can really help with that.
Great. Daniel, did you want to chime in on that? And if not, I'm going to ask maybe you and others a follow-up question.
Yeah, I'll just add that, you know, I think strong tenant associations, which I think we can all agree on, strong organized groups of people are important. I don't know if Dennis remembers, many, many years ago, we worked with OTA at a building on Columbia Road where they were having many of these issues. And we were able to help strengthen the tenant association where folks felt comfortable in identifying the issue and then reaching out to organizations, government entities like OTA, you know, to bring up these issues and to try to find solutions. So I think that in conjunction with, you know, strong laws that help protect people are really important. So yeah, as Beth mentioned, you know, the folks there found a solution for their specific problem because they worked together. So really want to underscore the importance of people being in community and working in community to address some of these issues. Because yeah, there is no single solution for these issues.
Great. Anybody else want to chime in on that point? And hearing none, my follow-up question goes to whether in reviewing the proposal, the SAFE Act proposal, we don't see a distinction in the term owner or property in terms of whether this could be applied to DC-owned, district-owned properties, public housing. And I wonder if the media reports seem to be sort of in equal parts about public housing as well as privately owned housing. Daniel, I think that most of your clients, if I heard correctly, are public housing residents. And I would imagine that you're seeing some good, you know, opportunities for not necessarily litigation, but just instances where assessment reports would, you know, have housing providers and tenants and government officials, you know, sort of create a meeting of minds about problems and solutions along the lines of the very simple solution that Beth just mentioned, for example, and you know, sort of a see-through fence being made not see-through, so to solve the problem about outside. criminal activity, intruding on the property. Do you have thoughts generally? And then my question for OAG, by the same token, would be, have you thought about the public housing aspects and whether there is a distinction, whether OAG would be equally inclined to venture into both areas?
Yeah, that's I think one of the big questions we have and want to explore more as this act moves through the process. As I mentioned again, or I'll mention again rather, one of the big major issues in public housing are the vacancies. There are, dozens of, if not more, of vacant units on the majority of the properties. So that creates a situation, of a lot of opportunity for folks who want to use these vacant units for, negative criminal activity. So I think we do want to see how this will work in conjunction with public housing. The other big thing is public housing, and this is a whole other discussion, I think, but there's a push to change the subsidy for public housing. So what does that mean as subsidies begin to change and they're no longer the traditional public housing? So I think these are other big questions that we have to wrestle with as the city changes. So yeah, but I think how public housing, how subsidized housing fits into the discussion is really important for us.
Gotcha. And OAG, I guess I'm going to amend that. There's a definition for owner that could and may not include or exclude public housing. How should that be interpreted? And is that something that's still being thought through in terms of the purposes of this bill?
Joel, I'm happy to jump in here, and thanks for the question. I'm just going to make some general observations. So one, I think, both the current Attorney General and our prior Attorney General are on record of sharing the concerns of many residents about our neighbors who live in public housing properties, who use subsidies administered by the DC Housing Authority to make sure they have safe and habitable housing, just like every tenant in the district should have safe and habitable housing. And because the Housing Authority is an independent agency, the Office of the Attorney General has, in general, the ability and has twice brought lawsuits against the Public Housing Authority. One actually related to nuisance. That was a case that was settled some years ago, and there is a current case about reasonable accommodations for tenants who live in public housing. And so, I think we're pretty clear that the District of Columbia Housing Authority, when they are a landlord, they are held to the same standard as other landlords. It's obviously a little more complicated than that, as Daniel, I think, was alluding to in some sense. But, I think our record there is clear in terms of how we think about those issues generally. I hope that's helpful.
Yes, and so the SAFE Act certainly doesn't rule out public being applied to public housing. Is I think correct.
Yeah,
it would apply.
I agree that as it's written now, it applies to owners of properties, and the District of Columbia Housing Authority is an owner of property. The Housing Code applies to them. The Nuisance Act applies to them. The Human Rights Act, applies to them. The Consumer Protection Procedures Act applies to them. And there are some examples where certainly our office has brought those cases where necessary, and courts have agreed with that.
Okay, great. The definition of owner in TOPA was controversial in that regard. I don't think the definition of owner here is complicated. So just to make that point. So Cristobal, I don't want to cheat the chat. Questioners, do you have more questions in the chat?
Yeah, I have a couple more questions. The first one is regarding a DOB security inspection audit. Would that be required on a regular basis? such as when renewing license, or only when there are significant concerns? This is a tenant question from the chat for the panelists.
Oh, as the bill is currently written, the assessment would be required in response to specific concerns, namely those triggers that I highlighted during the PowerPoint. So seizures of drugs, seizures of firearms, arrests for crimes of violence or dangerous crimes. I think the question of the relationship between security concerns, assessments, and licensure is an interesting one. And again, I think that's something that could be explored further at a public hearing, because we recognize, I think, that, maintaining security at a property is sort of not just making the changes up front, but also maintaining them over time. So it's an interesting idea that I think is worth exploring.
Joel, I have one more question. So how will building management companies be held responsible for actions by owners and management companies? For example, and it says many buildings in the city are managed by organizations that do not own the buildings, yet control the environment, especially on a day-to-day level. So the question is, how will management companies be held accountable versus owners of the properties?
So as drafted, the bill does focus on owners, with the idea that, owners are ultimately responsible for the conditions of their property, and that property managers would sort of necessarily be charged with implementing things that owners decide. I do know, I think, Joey, in your summary of other legislation, there was discussion of the Lamp Act, which attempts to expand how licensure of property managers is handled, or property management companies is handled. So I think it would be interesting to have some more discussions in the context of that bill, because we recognize that, yes, while the property owner is ultimately responsible, their property managers play a really important day-to-day role, and that they'll ultimately be charged with implementing a lot of what the SAFE Act contemplates as improvements to security.
Joel, do we have time for just 2 more, or?
I think we have time for 2 more. Yes.
Excellent. So one question is about vacant property, something that we talked about earlier. It says, the tenant writes, I am currently experiencing this problem. There is an old rental office, which is now an empty unit below mine. There are individuals who sleep inside, as well as participate in sale and use of drugs. The office has changed the locks, but the guys continue to go inside. So the management office has given up. So how would this legislation address these issues?
So I think, I think probably the primary way that the legislation would address these issues is through the security assessment process. I think it's a matter of, I think it can address it by through the recommendations that DOB makes. I apologize, I'm a little bit, I'm dragging a little bit. But I think the idea there is that if you have drug-related activity in a vacant part of the building, that if somebody is able to come out and look at the property, they may be able to identify some solutions, beyond sort of the locks on the doors of that specific part of the building. So the hope is that through a security assessment, DOB may be able to work with the property owner to come up with some additional strategies there. If anybody wants to add, I'm happy to sort of cede the floor for a second.
Well, I'll just jump in and add the last question here, which would be, is there an opportunity for the Office of the Attorney General to present similar SAFE Act recaps to tenants and tenant associations? And if so, how can they reach out to you all and request that information?
So we'd be absolutely happy to provide recaps to tenant associations and to anybody else who's interested in learning about the legislation. So I know at the end of the PowerPoint, I put my contact information up there. I can be sure to share it with Team OTA. And if you're willing, you can, it'd be great if you could facilitate us getting connected to folks. But we really want to be able to talk about the act. Number one, we want folks to know about the work that we're currently doing. Number two, we want folks to know how the act can improve their situations. And then number three, we absolutely want to get feedback from folks. We think that getting feedback from everybody who's involved in housing in the district, especially tenants, is going to help make this legislation stronger in the long term. And should it pass, we expect that, that input will also help with implementation. So please do not hesitate to reach out to us. We'd be happy to come out and talk about the legislation.
And we'll definitely facilitate the contact information of our OAG's office. With that, Joel, I turn it back to you.
Okay, and I think we do have an Amazon gift card give out to a few attendees, and I'm not seeing those names, Cristobal, so I'm gonna make some closing remarks and then turn it over to you for that part of it. But we want to thank the panelists for this really super enlightening discussion. We want to thank the Attorney General and OAG for introducing the SAFE Act legislation and adding an important part of the discussion about building safety. We look forward to continuing the conversation with OAG and with Daniel and other community advocates. On Thursday, we are having part 2 of our 2-part sort of mini summit for this year. The topic on Thursday at 6 p.m. is utility billing problems and potential solutions. And our education outreach team will be sharing a link on how to register for that event. Cristobal, are you able to do the Amazon card thing?
So we will be reaching out to the raffle winners who will be getting their Amazon cards and what have you tomorrow. Yes.
Okay. And with that, thank you very much, everybody. I thought that was a great discussion on a very, very interesting piece of legislation, adding to a very important discussion, policy discussion for OTA and the tenant community. So thanks to everybody and hope to see you on Thursday.